this episode of the Child Support Hustle Show, we have guest Greg Parsons. Greg is an advocate for disabled veterans and their due process civil rights regarding their legal child support obligations. He will be talking to veterans primarily, even though all Americans should be interested in this topic. He's going to explain his devised Parsons Due Process Affidavit, or PDPA, and why all veterans involved in family court need to write one. Disabled veterans are needlessly paying child support out of their disability compensation, usually indirectly, since the states like to deny due process so they can illegally attach to it their legal process called child support establishment hearings. Greg Parsons invites us to check out his affidavit and how it will help grant you federal civil rights that will allow you to keep all your VA awards. Your attorney probably lied to you, as Greg will be telling you, and stop giving state judges jurisdiction over your disability compensation benefits award. Get due process in family court for the first time since your divorce. Okay, good afternoon. We got Greg on the phone?
Yes, I'm here.
Okay, how's it going?
Good, thanks. I appreciate the opportunity to be on the show.
Well, I'm glad to have you on, and I just want to give a shout-out to all veterans serving our country in the past, in the present, and in the future. Okay, we got another call on the line. Caller, you want to announce yourself?
Hey, this is Drew. I'm calling in and listening to the show today to, just to find out, what veterans are going through.
Okay, yeah. Well, we got Drew back with us again today, and that's good too. So Greg, tell us a bit about your affidavit. Well, you can give us some background on yourself first, and also,
sure.
Tell them how people can get in contact with you. But go ahead.
Okay, sure. It's quite a bit to say. I'm a retired disabled Navy lieutenant.
Hey, go ahead. We got almost 2 hours. Say whatever it is. Get your message out. We got 2 hours. I'm going to have you on long as you want to stay with us.
I don't know if I have 2 hours of material, but I'll try.
Okay, go ahead.
But yeah, I'm a disabled naval officer. I graduated in 1982 from the United States Naval Academy, and in 1989 I was placed on the permanent disability retired list with the Navy for a life-threatening illness, and got married a few years later, had 3 children, and as you know, as the odds are pretty high these days, I got a divorce, and that's how the story really gets started. I won sole custody in my divorce back in 2003. I had 3 minor children, 3 really young children, and I had sole custody for about 2 years, and my ex-wife, through her mother, kept hiring attorneys, dragging me into court trying to get custody, which she eventually did. She eventually did after about 2 years. And so, of course, during that hearing, I had to have child support set, and I'm also qualified to receive Social Security disability insurance payments monthly. But the judge, for some reason, he did not use my VA disability compensation award to calculate an establishment the child support. He only went with the direct payment the children were receiving from Social Security disability, because the children, as you know, they get direct pay. If one of the parents is disabled, they get direct pay every month from that trust of the disabled parent. So the judge in 2004, when I lost custody, right at the end of 2004, he set child support to basically just be the direct payments that Social Security was providing already directly to the children in their name. So that went well. I lost custody, and that was tough to get over. And right, my ex-wife, she, like many do, she claimed that she was not receiving the payments because they were going direct deposit. I guess she figured she could fool the Texas Attorney General, and apparently she did fool, and they believed her that I was not paying my child support, my $425 a month order child support, which was, again, the direct payment of the Social Security. So she she filed that complaint with the Attorney General, and there was an alleged arrearage of over $20,000, and she took me back to court to modify the child support in 2009. And this time the judge, despite the fact that this time I even had representation, the judge used my VA disability compensation award in establishment. In other words, he said I had to pay a certain percentage of it every month to the children. And I had a gut feeling that was not legal, because I was fairly familiar with the 38 U.S.C. 5301, 38 U.S.C. 5301A grants rights, federal civil rights to the veterans, disabled veterans compensation. So I knew that law, but I just didn't understand how the judge was not adhering to that law. Of course, it was not cited by my attorney. So about a year later, I started trying to figure out what had happened to me, why I was having to pay so much more child support, even out of my VA disability comp. And I joined a group, a Yahoo group. It was called Area 5301, and I joined them in late 2010. And I just started finding out there was a lot of veterans that were having their disability taken in child support, and I was trying to learn the laws and regulations to see if this was legal. And a few of us have pursued it since 2010, and we've concluded that it's not legal what they're doing, despite the fact that they fall back on a U.S. Supreme Court ruling in 1987 called Rose versus Rose. We've actually read the case, and they don't apply the whole case as is. Plus, U.S. Congress, and at the time President Reagan in 1987, he was president. He was a very pro-military president, and they would not let that stand. They did not agree with the chastising they basically got because the U.S. Congress had written extremely deficient laws that the Supreme Court justice has pointed out in the Rose case. So they immediately got to work, and in 1988, they got rid of the old Veterans Administration, and they signed into law the Department of Veteran Affairs. And that's primarily the reason they did that, was because of the Rose decision that was affected the disabled veterans and when it came to child support. And they've since repealed all the laws that were cited in that case, and they've rewritten one of the primary laws, which was 38 U.S.C. 211 at the time, and they've repealed that and rewrote 511 to include state courts, because that was one of the deficiencies that was cited in the 87 case, was that the wording of 211 didn't say state courts or any courts, it just said U.S. courts. So now it says any court. Any courts now. Another huge development was the fact that Congress was watching like a hawk what they call apportionments. And apportionment rulings is where the veteran has to have a claim filed on his VA disability when it comes to his dependents, and that claim is called an apportionment claim because, in short, it means it's a ruling as to whether or not the dependents will be granted a portion, hence the word apportionment, where they'll be granted a portion of the veteran's disability benefits. And it's each individual disabled veteran and their dependents, they have to look at each case and make a ruling on it, and that's by law. And one of the other deficiencies cited in Rose was that there was not any real true guidelines for the states to go about, applying for these apportionment claims. There was no guidance. Well, in 1998, the Commissioner of the Federal Office of Child Support Enforcement, Commissioner David Gray, I believe his name was, he issued a directive. It was called IM as in India Mike -98-03. It's an informational memorandum. It's a federal directive for all. It was directed to all the Title 4D agencies in all the states and commonwealths. You know, Title 4D is the child support agency set up under the Social Security Act of 1975 for the states. And so now there is a directive. There's a directive that tells exactly the steps that the states and commonwealths are to go through whenever they have a disabled veteran, you know, with compensation in a child support hearing. So I was starting to learn all these things, and one of the group members from Texas, he had an ongoing, very contentious child support situation there in Texas. So he was digging into his file, the VA file, to see what he could gather as far as information goes. And he came across this 4-page letter that was written by the Houston Regional Council from the Department of Veteran Affairs to the state of Texas. This was in 2002. That basically said, look, you know, Mr. Williams, he's not retired with the U.S. Army. Therefore he doesn't waive a portion of military retired pay. We can't garnish this money because the state was sending all these garnishment orders to all these disabled veterans. And the Houston Regional Council was getting tired of all this paperwork, saying, look, I can't by law garnish this money. Why are you sending us all this paperwork? You know, why are you sending us all these income withholding orders? So when I studied that letter, I learned a lot, and it kind of dawned on me that veterans were not getting due process when it came to the family court hearing for child support. You know, they were not getting the ability to present whether or not they waived a portion of military retired pay in order to receive their VA disability compensation. And that's something that you have to do, because under 42 U.S.C. Section 659, that's the garnishment code, U.S. code, and it tells, you know, it tells in there if the disabled veteran does not waive a portion of military retired pay, then by definition his VA disability is not remuneration for employment, and therefore he has certain civil rights. One being, you can't garnish it. And getting back to IM 9803, that was the first part of IM 9803, was it described, you know, 42 U.S.C. Section 659, which we just went over, talks about whether or not the money is remuneration or not remuneration for employment. And then the second half of IM 9803 was the directive, federal directive, that gave specific steps for the states to, the states' Title 4D agencies to submit an apportionment claim. Whenever you can't garnish the money, then the only jurisdiction then over that money is whether or not the Secretary of the Department of Veteran Affairs makes a ruling that the children, the dependents, are entitled to a portion of the VA disability comp. It's not up to the states anymore. The states have no jurisdiction. They have no subject matter jurisdiction over whether or not they can set the child support. Yes. Yes, that's the law. If you read 38 U.S.C. Section 511, which replaced the repealed 211, that's the new law post the 1987 Rose case, and that was written. That became law, U.S. Code in 1991, and it says that once the Secretary makes a decision on the provisions of benefits for veterans and their dependents, you know, a la an apportionment ruling, then his decision is final and conclusive, and that no other official or any court has any say-so in it. And I don't know how it couldn't be more clear that the states have absolutely no jurisdiction over the money. Once they are afforded the ability to define whether or not it's remuneration for employment or not. And of course the states still hold on to the fact that, well, we have Rose versus Rose and we can take the money, so we do. But they're holding. It's like they're holding on to Dred Scott. Nobody cites Dred Scott because that's not the way it is anymore. Not in this country.
Ancient history. How much power did you have? Okay, I know the states want to do whatever it is they want to do to go after people and to get money. How did the military feel about it? Whose side can you sort of see the military they're taking on this, or what's their take on what the states are doing?
Well, in my example, I'm a Chapter 61 under Title 10, permanently disabled. In other words, I'm retired with the U.S. Navy because I have a percentage disability. The other option is that you can retire with at least 20 years or more. So, given that, in my case, what's happened is the state of Texas has sent numerous, at least 10 to 12 income withholding orders to DFAS, which is the Department of Defense. That's their Finance and Accounting Services, DFAS, and that's where they would, if I had retired military pay, which I do not, then they would garnish the money there. And so we've come across a couple of examples where the veterans are permanently disabled and they have a percentage disability, and therefore they're not supposed to be garnished, but DFAS has gone ahead and said, back to the individual Veteran Affairs Regional Office, because the VA has to call in to DFAS to find out whether or not the veteran waives a portion, of military retired pay to get their VA pay. That's how VA finds out. They call DFAS, and sometimes DFAS incorrectly tells the VA, he's waiving a portion of military retired pay, when that's not the case. And subsequently, I've run across a couple of veterans who have had their VA disability illegally garnished, despite 42 U.S.C. Section 659 and the corresponding Code of Federal Regulations 5 CFR 581.103, paragraph C, paragraph 7, which clearly states that if the veteran doesn't waive a portion of military retired pay, you cannot garnish it. So
Now tell me this. I'm an advocate member of the Child Support Hustle, and one of our major missions is to educate and bring awareness about the reasons why child support is unconstitutional. What is the military doing to educate the veterans on what their real rights are when the states are actually overstepping their boundaries?
Well, there is no education. They don't warn the troops or sailors or anything about all this, which is, I just had a guy sign up today. He's active duty Army, and he was getting an eyeful reading all the information. He goes, wow, I didn't know all this was going on for all the disabled veterans. I said, even though you're active duty, it doesn't hurt for you to go ahead and learn this information, because, unfortunately, the odds are you may be one of these veterans. You may become disabled, and you may become divorced with child support. And on the other side, he can reach out to all these other active duty buddies and tell them, hey, did you know this? Did you know that they're doing this to disabled veterans? So it's, that's part of the reason that I have the group that I have at Facebook. It's called the Disabled Vet Child Support Info Group on Facebook, and I have that primarily to educate people, but the biggest reason I have that group is because I have the Parsons Due Process Affidavit, as I was describing previously with that 2002 Houston Regional Council letter to the state of Texas. I knew that veterans were not getting due process in court, so therefore I devised an affidavit. I just call it the Parsons Due Process Affidavit, the PDPA. It basically lays down all the federal civil rights that the disabled veteran has when it comes to child support. And currently I have over 700 members, and that's a lot of disabled veterans on Facebook that are not having their due process.
That's a lot of people. Think about all the ones. Yeah, just think about all the ones that's not standing up. Just like I hate to see a lot of homeless veterans. You know, somebody needs to stand up. There's no way these people should serve their country and come back and they can't even get a roof over their head. Let me ask you about. Go ahead and comment on that. Give me your comment on that before I ask you this next
question. Well, you had said homeless. You had brought up the homeless. Yeah, you brought up the homeless, and I was just going to add that I believe it was in 2010, the American Bar Association and I believe it was the Office of Child Support Enforcement and the Veterans Administration, the Department of Veteran Affairs, they all three got together and they did some studies on homelessness. And one of the things that they found was that child support for these disabled veterans was one of the reasons they were homeless, because the states were taking so much of their money that Congress intended for them to have to live, you know, to have money for rent or a house. But the states were taking a big percentage of it in these child support hearings.
So what it looks like the state, no matter if you're a veteran or a civilian, you know, they're violating people's civil rights across the board.
Absolutely. We have a good friend of mine, I was telling you, I've been studying since 2010 in the original group that I was in. His name is Jan Iannucci. He's up in the Detroit, Michigan area, and he currently he has a federal civil rights lawsuit against the governor of Michigan, the Attorney General of Michigan, State of Michigan, and several attorneys who have illegally, we feel, has illegally convicted him of felony non-support, even though and that's despite the fact that he has a Department of Veteran Affairs special apportionment denial claim ruling. It says plainly in the ruling that no portion is to go to his children, to his dependents, because it would create a hardship, just like the Code of Federal Regulations states. If that's the ruling, that's the ruling.
So under that ruling, is the father allowed to select how much he actually want to give, or is it more from a voluntary point of view?
What it means, when you do the apportionment claim, both the non-custodial and the custodial parent gets to submit what kind of financial resources they have and all the expenses. You know, the VA wants to look at proof of, are you visiting the child? Are you spending time with the child? Which means that, of course, if you're visiting the child, if you don't have custody of the child, like so many of these non-custodial disabled veterans, you have to have money, of course, to travel and see them. You get to have them over. You got to feed them. You may have to buy them some clothes. They're expenses. So the VA looks at that during the apportionment claim. The veteran gets to submit all the evidence that, yes, I pay this much when I see my child. And, included in that are attorney fees. I mean, let's face it.
Absolutely.
All these attorney fees are by far the biggest expense we have as disabled veterans. If we have these child support hearings every 3 years or so, it gets to be expensive. And then, of course, the reason you're having to spend all that money on attorney is because you have a child, by definition. So that goes to child support. So the VA looks at that and says, yeah, that's an expense.
Uh-huh. Yes, it is. And think about what, there's no equal protection either. If the person with the child in that custody, they're going to be backed up by state money, and they can keep filing and keep bringing you back into court. They'll make you spend all your money just trying to defend yourself from being stripped of everything you got.
That is correct. That is my experience. And it's not only my experience. It's many veterans that I know have had very similar experiences.
Yeah, and that's the bad thing about it. And here in Alabama, I know there's been a couple of cases where the person gets there and they will only let them get a court-appointed lawyer one time in the whole entire case. After that, they'll be like, well, you already used a lawyer. It should be every time I have to come before you, I'm eligible for equal protection under the law. Why do you have to give me a limited of times that I can come and use a lawyer, but you got all the money in the world to hound me down anytime you want to send me some papers?
which is the reason that I came up with the PDPA, the Parsons Due Process Affidavit. That's why I came up with it, was because basically with this affidavit, it asserts all your rights, and you really don't need an attorney, at least not on the money side of it. You don't need an attorney because these attorneys were not telling the judges all these due process rights that the veteran has anyway. They were just mum, you know. They just said, yeah, we can take your money, we'll take it.
Yeah. Hey, hold on one second. We got a caller. Let's see. Okay. Yeah, we got a caller. Caller, you're on the line with Greg Parsons.
Yes, that must be me, Roger Southfield.
Oh, hey, how's it going?
Hey, I just
good, Roger.
Just came in. I just want to hear what was going on. I know there's a big discussion tomorrow, but again, I wanted to let you know about a few more things that we're all getting going on together right now. It's really exciting.
Yeah, yes, it is. It really is. It really is. I want to thank you for calling in. Roger, could you tell Greg something about yourself real quick? I know that they just passed, this might not be on another subject, but I know Greg is concerned about all veterans.
Yes.
They're passing, the Senate is passing this thing where veterans will have access to medicinal cannabis. So I would just introduce you. Roger work with a lot of groups that's trying to help veterans and everybody else in the States. We should have free access. But today, Roger, we're talking about this affidavit that we come up with. We're trying to help veterans keep all their money. They need access to whatever medically that can help them. And we've had some veterans here in Alabama that served their country and lost everything they had just because they were treating their post-traumatic stress disorder with cannabis, stripped of everything they had. And they wasn't sellers, weren't dealers. They were just treating. They didn't want all the medication. But that's on another story. Roger, you want to say something before Greg tells us about his affidavit?
Yes, again, Greg, I want to thank you again for thinking about our veterans. That's the most important people I think we need to think about today, because we wouldn't have a free country today to be practicing what we're trying to practice now.
Well, I agree with you, especially on this Memorial Day weekend, Roger.
Again, I owe it all to our veterans to give us this chance, and I think they want us to unite and become a government ourselves to show we're responsible to the rest of our governments, that we can become a part of them.
Exactly.
Okay. Yeah, that's exactly right. If any of our listeners back there catch tomorrow's show, Roger will be on United Voice with Sherry and Deanna, a show that's on this network on Sundays, and I think that their topic is what we're just not talking about. But Roger, you hanging there with us if you want to, and you can chime in when you get a break in between Greg talking. But right now, Greg is going to tell us about his affidavit.
Great, Greg. Please, I'm all ears.
Okay, well, like I was saying, I came up with the Parsons Due Process Affidavit for these disabled veterans that have child support legal situations. I came up with it a couple of years ago, and it stems from the 2002 Houston Regional Council letter that was written. It was found in a buddy's child support file there in the VA. So anyway, basically it just lays down all the civil rights that the disabled veteran has, and you know, to really go over it may be kind of really technical and boring to be on the radio, but it's typically it covers about 12 points. One of the things that it stresses that also applies to some of the other non-veteran child support non-custodials is a code of regulations called 45 CFR Section 302.56, and basically that's just a federal civil right that all non-custodial parents have if they have evidence when they go into either a judicial or administrative proceeding. If they have evidence that can rebut the state guidelines, state statutes, when it comes to child support establishment, then they are to be afforded the right to rebut that. And that's the whole basis for mine, because as a disabled veteran, we have a federal directive that tells the child support agencies what they're supposed to do, right? And as I'm referring back to IM 9803. You know, when it's defined, when their disability is defined, not remuneration for employment. So you might take a note and take a look at that and see if you can come up with with anything as far as rebutting if you're a non-veteran. That's a nice little federal right everyone has.
Greg, tell me this. I'm actually a military brat. My father served 37 years in the U.S. Army, and I knew how we grew up. You know, we had a household where we didn't need for anything, but it was working middle class.
Of course.
When the state is submitting these child support garnishments, as a veteran that's no longer active in the military, is it garnishing 20% of the wages or 50% of the wages? Share that with us.
Well, I mean, that's why they have, Congress has passed 42 U.S.C. Section 659 is to prevent garnishment from these disabled veterans when they do not waive a portion of retired military pay, and it's extremely rare nowadays whenever a veteran has served, over 20 years or more, and actually has to waive a portion of their military retired pay in order to get their corresponding 100% disability with the Veterans Affairs. So it's very rare. So, yeah, that's why 42 U.S.C. Section 659 is written, is to prevent that. But I know cases where the veterans, like I said, I know a couple of cases where the Department of Veteran Affairs is illegally garnishing their money, despite that U.S. code.
So they're violating their own law.
Fortunately, one of the veterans I know, he's currently filing a lawsuit against the Department of Veteran Affairs, as well he should.
So have you ever been to, approach the military and said, hey, you guys need to provide more education for veterans who are, retiring or processing out of the military, and to sort of support that of what they need to know on their way out? Because it is an adjustment once you get out of the military anyway, back into civilian life, but to be basically blindsided by child support orders, that definitely could be devastating.
Yeah. Oh, yeah, trust me, not only myself, but other disabled veterans I'm aware of have personally written the military. They've written the Secretary of the Department of Veteran Affairs. They've written the state legislators. They've written the Office of Child Support, the Federal Office of Child Support Enforcement. And, nobody cares. They just keep saying, hey, it's not our prerogative. This is a state issue, civil rights issue. So what we've learned is that we have to go into a high court, be it federal or state. We have to win. We have to win a case against Rose, and we currently have a couple of those cases pending. We have a federal case pending.
How many disabled veterans do you believe this is impacting?
From what I've heard, it's the majority. It's the rule. It's not the exception.
Okay, I know you know more about this than I do. What about, tell us about VA disability, and I know that it can't be used as an asset in a divorce. Did you get any protection under the Uniform Services Former Spouses Protection Act?
Right, that's another thing that's not being allowed to be, discussed as far as due process goes, because that's one of the first things that the state is supposed to determine, what your Title 10 status is with the military. They have to define what's disposable military retired pay and what's not, and so under USPA, the Title 10 U.S.C. Section 1408, that's all defined. And that's another thing that the state courts are not allowing in their hearings. They just breeze right over it and just say, when you go in, they just say, you're a disabled vet, okay, we can take your money. That's their due process. That's all the due process they get.
Yeah, it just seems like to me that as far as everything else going on with veterans, as far as housing and getting the proper medicines you need and health care and seeing a doctor in a timely manner, it seems like they also want to break you financially as well.
Well, it's as if they've declared war, you know, especially the family court attorneys, the associations. It's as if they've declared war on us.
Yeah.
And that's exactly what this is. It's a war being declared on not only the family, but with it being no gender bias, it's been a war declared on father.
Right. So I will come out and say, you know, that all these family attorneys, the majority of them, they're domestic enemies of the country. And veterans they take an oath to support and defend against domestic enemies. So.
And how long did you fight this in court?
Well, we're always fighting it in court, and we have, like I said, we have the federal lawsuit pending. It's in its 5th month now, and the federal magistrate has yet to dismiss the governor of Michigan or the attorney general or the state of Michigan. They haven't been dismissed yet, that's very hard to do. It's very hard to sue the state.
The state has criminalized all non-custodial parents.
Yes.
Just bottom line.
I agree with that. They've declared war. You know, basically they're a silent weapon for a quiet war. They don't allow the children to have a father. You know, they get very limited time with them.
Exactly. And I'll tell you another thing that we talked about this on the previous show. When you go into this child support hearing, that judge does not want to hear anything about their parental rights as far as visitation and things that matter in a child's life, like their spirituality, like their social coming up, who their friends are, what courses to take during school, and which ones. You have nothing else. You become totally financial to the courts. They don't even want your presence. And it's been some judges who actually think that it's dangerous for a father to have contact with their kids once he's out. They don't want him back in the picture, period.
Of course, they want, you know, so many of these children, you know, when they grow up, they have problems. They have mental issues. That's all stems from the fact that they didn't have their father time to train them, to teach them what's going on in the world.
Okay, we're going to take a quick, it's not a quick break. We're going to take a little quick, small, short break. When we come back, Greg, I want you to tell us all the avenues that people can contact you, and we'll continue the discussion on the other side of this break.
All right, thanks. All right.
RMCUD. To the children and families. It's a pleasure, ladies and gentlemen, to introduce to you Ms. Carol Rhodes.
Thank you. My purpose today is not to dazzle you with my oratorical brilliance and skills. I merely want to say that I came to the 37th Circuit Family Court to make a difference. I was well qualified and hoped to be able to help Michigan families of divorce and separation. But early on I realized that the system was not designed to be child-friendly. No friendship nor honest conciliation were ever allowed in the family justice system between caseworkers and clients. It was all about money. How to get the federal and state tax dollars that were allotted each case for enforcement. In fact, our director would say regularly, we aren't the friend of the family, we're the friend of the court. We stumbled over ourselves trying to get more Title 4D cases on our records and to increase the child support orders because the federal government granted huge allotments for each case we enforced. In the years I worked in the system, I witnessed regular defection to clients that was mandated by office policy. I saw gender bias and discrimination. I saw records destroyed. I saw office policies and rules change from week to week for the profit of the agency. I saw hundreds of pleas for parenting time or enforcement get buried because there is no money in enforcing custody or visitation issues. Increasing the child support money that came into our offices was the goal for each of us. We were rated according to how much money we brought in through asset seizures, income garnishment, court hearings, warrant issue. We wrote the orders and then we enforced them. The judge merely rubber stamped our efforts. My director proudly told me that the Child Support Enforcement Agency was the darling of the circuit court and that we actually made money for the judge and the court. Unlike the sheriff's Department, and so many others. Our county or state was not an exception to the rule. We were one of the most successful counties, and we shared training with other counties and states so they could learn how to maximize their efforts toward increased collections. We were not only told to withhold information, forms, policies, laws, and statutes from our clients with questions, but we were forbidden to help them obtain legal relief from unfair situations beyond their control. We were instructed to quickly help those who were demanding increases in child support, but we were threatened with losing our jobs if we should breathe a word to encourage an injured or unemployed payer to petition for a reduction of any kind. For the years that I worked in the system, I put my job on the line whenever I helped any of the parties in trouble. We were not to get personally involved. The children or parents, we had nothing to do with that. I was derisively accused of wasting my time being a social worker. We worked closely with Child Protective Services and Family Independence Agencies, and they were the same way. No one wanted to improve services or hear about abuses within the system, because every worker in these huge bureaucracies was trying to keep his or her job by covering up any errors or problems. I had 6 secretaries underneath me, unlimited power in my 401k and my office to lose if I should rock the boat. But rock the boat I did when I wrote the book, Friend of the Court, Enemy of the Family. Families that were bleeding from the pain of divorce and separation were insulted, tricked, lied to, and deceived by persons without adequate training to be making those kind of judgment calls. Most of the custody determinations were made by unwed, childless individuals who were totally unqualified to hold the lives of so many in their hands. The determinations were made on the basis of the most child support that could be ordered for each case. Fathers or non-custodial parents were stereotyped as payers only. The court and most caseworkers felt that fathers were unnecessary and possibly dangerous for the children to have contact with. The child support system is an adversarial system. It encourages parental alienation and court battles. Children are pawns in an expensive and elaborate game of winner versus loser. Attorneys coming into the picture further divide the already fractured family and insulate the parents from communicating with each other. Usually after attorneys and agencies become involved, new and creative charges of abuse, neglect, and addiction enter the picture. Many times these are convenient charges against innocent family members guilty of no offense even after the partner left. I heard many unwed fathers tell me that they begged the mothers of their children to marry them, but that the mothers were unwilling to give up the welfare check in exchange for a husband and father in the home. The most outdated picture of the father leaving the mom and kids to run off with his secretary is all but a thing of the past. In Southwest Michigan, 98% of the divorces are initiated by mothers and unwanted by the father. These aren't abusive fathers either. Equal parenting is not a men's issue. I was a single mother for most of my children's lives, and I know what children need most is the love and balance 2 fit parents can give them. Money can never make up for the loss of a parent. Divorce or separation should not be the reason some kids will never get to know one important part of themselves. Equal parenting does not do away with child support. Child support takes on a whole new dimension for children with 2 loving parents instead of just one. I am humble as I stand in the shadows of one of our greatest founding fathers. Here in this place, another great father, Martin Luther King, announced to the world that he had a dream. Well, Mahatma Gandhi told us that we must be the change that we want to see in the world. Are you willing to be that kind of change? Thomas Jefferson said that we only have the rights we're willing to fight for. Our Constitution gives all the right to life, liberty, and the pursuit of happiness. But for some children, the right to have 2 loving and involved parents in their lives has been usurped by the courts. Courts rule according to precedent, and the precedent has been biased against one parent in the past, branding him or her the non-custodial parent, which in itself is an insult. Equal parenting by 2 fit and willing parents is what our courts and agencies must go back to believing in. Laws and fiscal policies must not facilitate conflict and adversarial relationships between parents. It's only a matter of time before the civil rights of families will be restored in the courtrooms of our nation. Thank you.
No conversation.
Thank you, Carol. Okay, we're back with the Child Support Hustle Show. We've been talking with Greg Parsons. Greg is an advocate for disabled veterans and their due process civil rights regarding their legal child support obligations. Okay, we're back for the break, and before we go any further, I want Greg to let our listeners know any way that they can help his cause, how they can reach him, Facebook, Twitter, however it is, so they can keep in touch with him. Okay, Greg.
Well, I appreciate it. Right now, the only web presence that I have is in my Facebook group, and the group that I have is called Disabled Vet Child Support Info, and currently that's the only way that you can really reach me. I currently have about 740 members, and I haven't had it established quite a year yet. I think in June sometime is the first year anniversary coming up.
Yeah, that's congratulations on that. That's a lot of people to get together, though. Each one tell another person it's going to grow. It's going to grow, because I had no idea the issue was as bad as it is. So I'm glad you enlightened us.
It's slowly but surely the word's getting out there. Unfortunately, it's only on Facebook right now. I was trying to get another website established, but I haven't been able to finish that up.
Okay, well maybe we can work out something with our network, because I would love to do something with veterans, and we can start from that point right there, and get the message out on all their needs.
Well, I appreciate it. Maybe you can house the Parsons Due Process Affidavit. I have a Microsoft Word template, and what I do is I have that in the group, and I direct all the new members to read it over and to write their due process affidavit. And it's a template, so all they have to do is change.
Yeah. Well, we'll make sure that affidavit gets on HuntsvilleBlack.com, and we'll blast it out to several thousand people. Just send me that, and I'll make sure within 24 hours we'll have it up. We'll definitely.
I appreciate that. But of course, yeah.
No, go ahead.
I was just going to say, of course, you know that when we're talking about disabled vets and child support hearings, we're talking about a very, very small percentage of the population, but it's an important population.
Yeah, that's exactly why I said we can start from right there and address all their issues. You know, if we don't talk about, let's just do something with veterans. You know, the child support, the homelessness we were just talking about. And we can talk about what we just had the caller call in. We can talk also about veterans being able to get the medications that they just now are proven through the Senate that they can't have access to medical cannabis. But we can address a lot of veteran issues, and the child support is just one, just like the medical part of it is. And it's just come together to do something with veterans. But tell us anything else you want to tell us that stands out in your mind about what's going on with veterans and their benefits. It seems like that federal law would trump state law.
Well, of course it does, but like I said, the states are holding on dearly to the 1987 Supreme Court ruling of Rose, when in fact, if they were to read all of Rose, it clearly states that even in 1987, the late Associate Justice Antonin Scalia said the question of apportionments is not before the court in this particular matter. So the apportionment question has yet to be answered. It's not in Rose, because the veteran, his name was Charlie Rose there in Tennessee. He knew about apportionment rulings back in the 80s, and he said, you know, you guys are supposed to apportion my money. But of course, the old Veterans Administration, they probably got his claim and threw it in the trash, and he was never afforded his claim, his apportionment claim. So that was one of the reasons that President Reagan and Congress was so upset with the ruling that was handed down in 1987 against the disabled veterans. And that's why they got rid of, they immediately got rid of the Veterans Administration. Within a year, it was gone. They voted in the Department of Veteran Affairs.
Okay, you said there's a small percentage of veterans. Maybe that's why the eye is really not on it as hard as it should be. But they should be.
No, what I'm saying is that. Yeah, what I'm saying is that disabled veterans, in terms of the population, is a very small percentage. But in terms of all these disabled veterans who have to go into child support hearings, proceedings, the vast majority of them don't even know that they're having their money stolen, that they're not even having their rights presented by their attorneys to the courts. They're totally being denied equal protection under the law. The 14th Amendment is not even, it's just being run over, trampled. It's just defaulted on.
Yeah, and you throw in those Title IV funding, and then you get a state-appointed attorney who works in the same office with these people, you're really in trouble.
That's correct. I call it the modus operandi is 42 U.S.C. Section 658 Alpha. That's the incentive money that these states are getting. That's why they're doing it. And they also, of course, in Section 655, they get they get 2/3 of the fee. The federal government sends them 2/3 of the cost of the fee. Even more money. Yeah. It's millions. Yeah, it's millions of dollars in Texas.
Yeah. Yeah, it is all across the country, and the majority of the people owning this don't actually owe the most to the parent. They owe the most to the state, who's hitting it with that 12 to 15% every 30 days.
Yes. Yeah, they love to build up those alleged arrearage.
Yeah. It's a hamster wheel, nothing but a hamster wheel.
Well, Greg, if you right now, Greg, I want to let you know you have my 100% support, and you can use my page anytime.
I appreciate it.
Again, I think we've got something going, and again, with what I'm trying to promote, a compassionate care center, there's room for a vet there.
Very good. I know that's one of the issues that's on the hot burner right now is the medicinal marijuana. I know that's a hot topic.
Okay, Roger, what's going on out there in Texas that you know of that could be working, that could help veterans out there as far as the medical cannabis? Do you have any news out from Texas and what they're doing for their veterans out there?
No, I don't. Again, I'd like to have some great news that I'd like to announce that Mexico City is now offering to come up to Mexico City to show Mexico City how we can work together with our two countries. And again, that could bring in our vets too, I think.
Okay. Well, we're getting some progress going on there. Okay. Greg, do you want to say anything else up to wrap the show up?
No, I appreciate the opportunity to come on and tell all the listeners about the Parsons Due Process Affidavit. And again, if they want to get in touch, you've offered your assistance there on your end. But if they're on Facebook, they can go to the Disabled Vet Child Support Info Group, and that's where they can actually see an actual due process affidavit.
Yes, and they can also go to find more information on other matters because veterans have kids, they have family members, and everything else. They also can go to the childsupporthustle.com and learn more about this system and how it's working and how we need to change it. You can also get Child Support Hustle Show on Facebook. And so with that being said, I'm going to play a study. It was a breakthrough study about how child support orders